Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And we're here in Murray, Kentucky, talking to injury attorney Jeff Roberts. And Jeff, you handle a lot of workers' compensation cases, and a lot of the things that we've talked about as we were preparing for this episode is how this COVID-19 pandemic has really just kind of bogged down everything. And what's kind of interesting about your practice is that you not only are seeing this in the workers' comp arena, but you're seeing this in the Social Security arena, which is another area that you handle, as well as the civil law where you're doing the normal personal injury cases. Let's unpack that and kind of help set some expectations, kind of talk about why that is happening.
Sure. The pandemic obviously has affected all areas of our life as we go about our lives, and even though we're several months in, it still has restricted a lot of in-person activities from that standpoint. Early on, when things started shutting down back in March, April timeframe, I know the Department of Workers' Claims shut down the final hearings in workers' compensation claim. I believe it was late March, about the same time the Supreme Court of Kentucky kind of shut down in-person things at the courthouse except for emergency matters. And that, really, some others that were more in tune with what was going on may have realized it was going to go on 6+ months. In some respects, I really thought, when they said let's shut it down to flatten the curve, and to hope. And from my perspective, I was hoping that we would be able to get on top of this pandemic or this virus early on, and things would be opened back up by June. And I didn't think it's going to really be as much of an effect as what it's turned out to be. So, a lot of what attorneys do, especially injury attorneys, is an in-person process. A workers' compensation claim, the hearings are in front of a judge. I mean, we would go to a hearing site. It wasn't a courtroom like you would normally think of, but because they are an administrative process, but we'd go to a hearing site and have a conference in front of a judge to discuss issues, or we'd have a final hearing in front of a judge where the injured, my client would get to testify and explain to the judge how this injury has affected them. The defendants could have any witnesses they wish to have present as well. And that process got shut down in March, so that cases that had final hearings scheduled in April just got pushed back. And these could be cases that have been in litigation for a long time, and that's the ending of the process as a general rule for most cases, is having that final hearing and getting the judge's decision in the case. So I and other workers' compensation plaintiffs' attorneys had clients that were looking forward to their claim being resolved, and then all of a sudden they say, no, we're not going to have in-person final hearings. The Department of Workers' Claims actually was pretty receptive, and they listened to the attorneys and how this was affecting their clients, and they switched over to or adapted to having Zoom video conference hearings.
You guys did that fairly easily. I mean, it wasn't flawless, but I mean, a lot of people transitioned to that, and it was a way to keep the cases going, to keep all the if it wasn't the actual hearing, it's all the things leading up to the hearing, where again telephone conference calls and Zoom video calls seem to work out. And to the court's credit, you guys were able to adapt to that fairly easily.
Yeah, the Department of Workers' Claims adapted probably as well and as quickly as any other agency that I deal with anyway. From that standpoint, when this occurred, I frankly. If you asked me in January what Zoom was, I would have told you that's
a show in the 70s.
Yeah. That, or when you want to see something up close on your phone or something like that, then you can zoom in. So, and I don't think I'd even heard of Zoom video communications back in January. And an organization that I am involved in, actually on the board of governors of the Kentucky Justice Association, when all of this stuff developed, they started doing seminars and doing talks to the members of those about, okay, there are these avenues that you can use to keep moving your clients' cases forward. So they helped to educate me and other attorneys that weren't familiar with this technology. I don't know how new the technology was at the first of this year, but anyway, it was new to me. And really, I was able to learn that early on in the process of when everything got shut down, or they were talking about shutting down, how we could continue on. Law offices never did completely get shut down because we were considered essential services. So we were able to keep the office open the entire period of time and keep moving our clients' cases forward, even though the pace slowed considerably down because of everything being shut down. At least we were able to do what we could in talk with our clients and let them know what was going on and keep them informed anyway as to what was taking place. So in the practitioners that I deal with, a lot of those were very receptive because they wanted to keep the cases moving forward as well. So we switched over to doing Zoom video conference depositions in cases or telephonic depositions in cases, so that we didn't have to gather together in one room,
right.
which we weren't supposed to do from that standpoint. And then by the Department of Workers' Claims in April had started looking into using the Zoom video conference and studying that and putting some of their IT folks into to that study, and they set up a little pilot project with two of the workers' comp judges to see how it was going to work out, and did it for a couple of cases, and it worked out well, and then they expanded it to all the judges pretty quickly. So by May, we were actually doing video conference final hearings via Zoom for workers' compensation claims, so we were able to get those cases started moving forward, which has been very, very beneficial to a lot of my clients whose cases were, or would have still be lingering on now if we weren't able to move those cases forward from there. Because a lot of attorneys are like myself in the standpoint that we think it's very important that the judge actually see the injured worker
face to face if possible.
Yeah, exactly. My preference would be face to face in the same room, so that when my client when my client's testifying, they can see how sincere my client is and see the difficulties that my client faces, and it brings it home more for the judge, at least to me it does, and for anybody else that is seeing my client in that setting. So I much prefer face-to-face, but my experience with doing things telephonically as far as a final hearing with the judge, it's not been very beneficial. So it's not something that I wanted to do because I thought it would be to the detriment of my client. And a lot of attorneys that represent injured workers felt the exact same way. And so being able to go to the video conference, and even though that is not the best case scenario for my client and for me and what I would prefer, it has been it's worked out very well, I think. And I know a lot of my clients, a lot of clients are a little uncomfortable with doing the video conference hearings, but once it got started and then after it was over with, I'd talk to them, and every one of them said that was a lot smoother and a lot easier than I anticipated it being. And some of them said it was a lot less stressful for them because they knew they were. A lot of times I have the clients come in here and we social distance in my conference room. But so they're in the room here with me, and we're more than 6 feet apart, but we're the only ones here. And they said, I was a lot more comfortable with it just being me and you in the room together and everybody else over video camera than I probably would have been if I'd been going in front of a judge.
Might be a little less intimidating, I would think.
Exactly. I think it is a little less intimidating to them from that perspective. And then so the workers' comp Department of Workers' Claims did adapt pretty quickly and has continued to move cases forward from that perspective. I've had final hearings by Zoom in cases ever since. In fact, I had one a couple of weeks ago in a case. The court system itself, like circuit and district courts, they shut down except for the emergency type hearings, and that caused the cancellation of a lot of trials. In fact, I was supposed to be in a jury trial in Graves County in May of this year, and that was canceled because of the pandemic and the restrictions that were placed on us. And trials were suspended up until September 1st by the Kentucky Supreme Court. Now the Kentucky Supreme Court has started allowing trials to take place again. And I know some have taken place. There's been some jury trials that have taken place, criminal and civil cases that have tried in some areas in Kentucky. Graves County, I think, has had a couple of criminal civil trials since September 1st. And there are some unique challenges there. I haven't had a trial yet, but I've talked to some folks who have done the trials, and selecting jurors, because you have to I know some have used extraordinary means in places outside of the actual courtroom to do the normal jury selection, to where the jurors could be separated, the proper social distancing for the questioning until you narrow it down to the 12 jurors that are going to be hearing the case.
You'd have to almost go to like a ballroom at a hotel or a gymnasium or something like that.
I know there was one that they went to like a big building outside. I think one actually may have used if I'm not mistaken, and I'm going off memory, but one I think did actually use a gymnasium of a local school to do the initial selection. Because at the initial selection, you bring in all the jurors. And then, at least in Callaway County, that's the way it's done. And everywhere in Western Kentucky that I'm aware of, all the jurors that are on jury duty for that court come in the day trial starts, and then you select from that entire panel down to get it down to 12 and ask those individual 12. And as one gets excused, then they bring another one from the seating area up to the jury box to do that. But everybody is sitting right next to each other out in the audience area of the courtroom, and so obviously you couldn't social distance 6 feet apart with that many people in the courtroom, and so they have had to look at other locations to do that. And I think that's going to continue for a period of time. And the court system, rightfully so, is going to give preference to criminal trials over civil trials.
That's more of a constitutional issue.
Yeah, exactly. The criminal defendant has a right to a speedy trial. Mm-hmm. And so they're going to get preference over the car wreck case, and they should get preference over the car wreck case. So the civil trials are going to be prolonged for a significant period of time. I expect that case I was supposed to try in May of this year, we've got it reset, and unfortunately we weren't able to reset that for jury trial until May of next year. But it actually may end up being fortunate, because it may be that long before we're actually able, with all the criminal trials, for that case to actually go.
You can work through the backlog and everything else. And,
yeah.
And that's something, when you look at this, is that whole ripple effect. You'd mentioned at the outset the workers' comp final hearings. Well, there's still new cases coming in. And so when the end of the line gets delayed, the beginning of the line just starts stacking up. It's like getting on the interstate coming back from spring break in Florida or something like that. I mean, it just never ends. But now you bring in civil court, criminal court, all these other factors now. and that line's just got to be immense. I mean,
Yeah.
I don't envy you guys. You're going to be busy, but the other thing is the ripple effect between the doctors who may be required to give an opinion on something, or maybe do an examination or something like that, where their offices are on limited hours or operations based on the whole COVID. So I mean, there's just been one big ripple effect after another.
Yeah, exactly, and that has occurred. I've had a lot of clients who were, telehealth is beneficial for a lot of things, and it's certainly better than not seeing your doctor from that standpoint. But elective surgeries were all put on hold for a period of time from that standpoint, and most surgeries are technically considered an elective surgery. It may be medically necessary to have a herniated, surgery for a herniated disc, but it's not a life or death surgery. So I've had a lot of clients surgeries that were put on hold for a period of time, and then the battle got less as time went on. Initially, I had fights with some insurance companies over that, and they said, well, his surgery wasn't put on hold by anything we did, so you're extending how long we're going to have to pay this guy lost wage benefits while he's off work. And it's like, it wasn't anything he did either, so you still owe these wages. And I had to talk to a few of the adjusters. Most of them did. I didn't really have to file any motions or anything like that. They come through instead of, and it seemed to be more wind than it was anything else, which I'm glad that's all it was. But those type of things it delayed a lot of medical treatment for my clients as well in that regard. And then on the Social Security side of it, Social Security has, I had hearings that were scheduled that got canceled because of COVID, and then they started setting hearings or switching hearings over from in-person hearings to the telephonic hearings. In as far as I know, Social Security still is not adapted to doing the video conference hearings through Zoom or through Skype or Microsoft Teams or any of those processes. And a lot of attorneys are like me, and they just don't want to do a telephonic hearing. They don't think that's the best for their clients.
Right. By telephonic, you mean basically a telephone hearing where they're just on the conference call or the speakerphone.
Exactly.
And I think you lose a lot of that. Like you said, when you're standing in front of the judge, they can kind of size you up, because there's still, even though this is the law, even though there are reports and doctors' recommendations, at the end of the day, it's still got to be some level of subjectivity in the mind of the judge. And being in front of that judge, I guess face-to-face is, as we said earlier, probably in the best interest of the client.
It is. At least in my opinion, it is. And I think at least my experience over 27 plus years now of doing this has borne out that in-person hearings are much better for my clients than video conference or telephonic hearings. Video conference are much, much better than telephonic hearings.
Yeah.
Telephonic hearings, I don't like those. When you see someone, so much of communication is nonverbal, and even on video conference, you can pick up on some of the nonverbal communication,
vocal inflection or something. But
yeah, exactly, vocal inflection and the wince on a face and things of that nature can be picked up on a video conference hearing that's not picked up in a telephonic hearing at all. And my experience has been that the results for my clients are much worse with a telephonic hearing than they are with an in-person hearing or even a video conference hearing. And so and I've talked to other attorneys who do what I do, and they feel the exact same way. A lot of attorneys are not doing the video or the telephonic hearings for Social Security, and Social Security, to their credit, Social Security is leaving it up to the claimant and the claimant's attorney on whether they're going to consent to a telephonic hearing. So if I don't consent to the telephonic hearing, my client doesn't consent to the telephonic hearing, then the telephonic hearing won't take place. And unfortunately, though, we're being delayed on when we can have those hearings in that regard. And you may have, there's always exceptions to every rule. There are some cases that are the evidence is so strong in my client's favor that I will go forward with the telephonic hearing, because I think the chances of losing are very slim in that setting, and there may be a situation where I've got a client that's, on the brink of bankruptcy, and so that individual, even though I tell them this ain't the best, this is all we got right now, and I don't know if it's if we're going to have in-person hearings in Social Security or video conference hearings before the end of this year, and they may say, I understand the concerns there, but where I'm at financially, I want to go forward with that hearing. And if that's the case, and we'll do our best we can from that standpoint. So.
You brought up an interesting point that you'll talk it over with the client. The client may have other factors that push that decision or influence that decision. But ultimately, whether it's workers' comp, Social Security disability, or even a civil case like you said, a car accident, it's ultimately the client that makes that final decision. You advise and you kind of help them weigh the pros and cons to those decisions. But ultimately, that decision is in the hands of the client to be made, right?
Absolutely. The client is the final decision maker. I will always advise them, and most of the time I will tell them this is what I recommend.
And 27 years of experience.
Exactly. But if they say, I understand that recommendation, but I want to do this, that's fine. And that, like I said, they are the decision maker on that and what they wish to do on how to proceed with their claim. Obviously, as long as it's within a legal and ethical realm, then that's what we're going to do. And we're talking about having hearings and things of that nature at this point. But that's on anything with going on with the case. And I usually will sit down with my clients, especially on major decisions like this, sit down with the client and talk with them about their individual situation, and then explain to them my concerns and how I think we can deal with it, and try to deal with their individual situations as best that we can. And then make my recommendation when I know what their individual situation is. And, most of the time clients will follow my advice, but there are some clients that are, and there's, like I said, there's sometimes after I have that conversation about what their situation is, and I tell them, normally my advice is that we don't do a telephonic hearing in this case, but in your situation, I think we should do that. It's your call. These are the problems with it. These are the benefits of doing it here. And, I'd rather have the telephonic instead of you going to see a buddy of mine who does bankruptcies.
Right. Nothing happens in a vacuum. There's always other factors involved that are outside the legal process, at least as it pertains directly to the injury and the resolution of the case.
Right.
So obviously this is prolonged. The resolution. None of these cases get wrapped up quickly in general terms. These are always lengthy cases, and now this may be extended even further. When a new client comes in, how do you begin to set that expectation, especially in light of what's going on with COVID? But how do you walk them through hey, this is really what you're in for at this point?
Yeah. Well, after doing it for 27 years, I have a decent idea on how long cases take. And every case is its own case, so every case is going to be different. And I can't remember where I heard the term, but somebody used the term one time, every tub sits on its own bottom, and that is true in this regard. Every case is an individual case, but I have that question asked of me a lot. A lot of times in the very first conversation with a client, they will ask that question, and even during the process, they will ask that question. And my first response to that is, I don't know how long your case is going to take. The first thing that's going to happen before we start to try to resolve your claim is you need to you have to reach maximum medical improvement. In other words, you have to be as good as you're going to get from this injury. And when you get as good as you're going to get from this injury, then the doctors can tell me what your permanent problems are going to be from this injury. And until that occurs, I don't know what your damages are. And I have the same kind of an answer actually when someone asks me what's my case worth in that initial conversation, and And they get a very, very similar answer, and that is, until I know what your permanent injuries are, I can't tell you what your case is worth.
It depends.
Exactly. And if somebody's telling you, 2 months after your car wreck, while you're still got a cast on and maybe facing surgery, and they're telling you what the value of your case is right now, you might want to ask them, how do you know what the value of my case is when you don't know what the full extent of my injuries are? Because I don't think anybody can, unless they've got a crystal ball and know how to use it. I don't think they can know that. And, clients want to hear a dollar figure at times, but I think it's better to tell them the truth.
Yeah.
And my experience is people much prefer hearing the truth than hearing what they think they want to hear.
As ugly as it may be,
yes.
But at least they understand it at that point.
Exactly. And then, in every case is different, but once they reach maximum medical improvement, then, and I tell them that, so when you reach maximum medical improvement, if it's a car wreck case or workers' comp claim or any type of personal injury, anything but Social Security disability that I handle anyway, then I'd sit down with my client and I would talk with them, and I tell them, we'll sit down and we'll talk about what the value of your claim is at that point in time, and then we'll make a settlement offer. In the case there. Now, Social Security disability there is no settlement offer. You go to a hearing and either you win or you lose. But the others, you can, there's settlements or there's a judge's decision or a jury verdict in those cases. So.
Well, and we've talked about maximum medical improvement, that MMI. We've talked about that in previous podcasts, and you've covered it on your website as well. But ultimately, that's when the doctor says, okay, we've gone about as far medically as we're able to go. Is that kind of the best way to think of it?
It is. It doesn't mean that you're not going to get any more treatment for a condition. A lot of times a person will continue to receive medical treatment, even may receive injections and things of that nature after maximum medical improvement. It is, but it's the point when the doctor says, okay, we'll continue to do treatment to maintain where you're at, but we don't anticipate you recovering any more from this. We're just going to try our best to keep you from going down from this position. So you may still get more treatment. Now, some people, you may have a complete recovery, and that's what I wish for all of my clients. But, maximum medical improvement doesn't mean no more treatment. It just means they don't anticipate you're going to get any better,
right.
And they're hoping to be able to keep you from getting worse.
Well, and that makes sense. And I guess the silver lining to this, even though it does take a while, you recently launched a blog post talking about back pay. You want to talk about how that works, especially workers' comp?
Yeah, in workers' comp, whenever we do resolve a claim, whether it's by a judge's decision or by a settlement, a lot of times a good chunk of that is, or a chunk of it, usually the future benefits are greater than the back pay, but I will obtain back pay for the client that will pay them back from the time that the temporary total disability benefits terminate, which terminates at maximum medical improvement, until we get the claim resolved. So we'll get, the back pay will go back to the date that last workers' comp check had cut off from that standpoint. And depending on how long it takes, if the person reaches maximum medical improvement, we talk settlement and we have the claim resolved within 3 to 4 months, it's not that huge of a back pay. If we have to litigate the claim out to a judge's decision, then that back pay can be substantial.
The insurance company on the other side says, no, we don't believe it. We're going to argue this point, or we're going to file a motion to delay this or to do something else. And again, that's when it kind of gets wrapped around the axle. But again, the benefit is if you're going to prevail in this case, you are still going to get all that back pay.
Correct. Yeah, exactly. And, the longer the insurance company fights it, the longer the back pay goes on from that standpoint. I know we've had a blog post about some cases I've got at the Supreme Court, and in those cases, that litigation, even after the judge's decision awarding my clients benefits, that's been in litigation at the appellate levels for
So
a
they
couple.
appealed it and said we don't agree, and they took it to a higher court.
Yeah, they took it to the Workers' Comp Board, to the Court of Appeals, and now we're at the Supreme Court. And even though I've got a judge's award, since that award's not final because it's up on appeal, and those cases, since it's the judge's decision, I believe both of them are probably the two I'm thinking of off the top of my head because I've written briefs on them fairly recently. The decisions are, from the judge probably 2.5 years ago, 2.5 years ago.
Wow.
There, so that back pay goes back there, plus the back pay before the judge's decision came into being.
So again, this can be a substantial amount of money depending on the situation that you're dealing with. But I guess take to heart. Jeff, you've got 27 years worth of experience here. You're going to fight every day for this. And,
Yes.
and you're going to push. You're going to push to try to get it resolved when it makes sense to resolve it. But again, knowing what you're ultimately dealing with, because you have taken the time to reach MMI, maximum medical improvement, is vital to the case. So again, wrap that all around now with the delays with COVID, and it's going to be a journey. It's going to be a bit of a journey. Right before we did this podcast, we had a gentleman in who was a previous client of yours, and I think you said that had been one of the longest cases from a workers' comp standpoint that you've handled.
It definitely is
And this was kind of pre-COVID to a point.
Yeah. His case really was not delayed by COVID at all. His was delayed by reaching maximum medical improvement. And the more severe the injuries are, the longer maximum medical improvement takes. And then you have some individuals who they have a surgery and are in a period of recovery, but then have setbacks and may have to have more surgeries. And I've had clients who've had 5 or 6 back surgeries or other types of surgeries from that standpoint. But yeah, that gentleman is he is in the top 3, but I suspect he is. I hadn't gone back and looked. There's one that may have taken longer for the same reason the gentleman kept having surgeries. He had he had an injury that caused him to be blind, and they were doing surgeries to try to restore his vision. And obviously, that client was like me. Whatever you can do to get my vision back, I'm all up for it. So he was doing everything possible, and we were doing everything possible for him to try to get him his vision back. That case may have been longer. They're both about the same time period, but unfortunately, some cases drag on for a long period of time. Now, in both cases, I was able to keep them on the temporary total disability benefits for the vast majority of that time period, though.
Right, so it helped it on. But again, that's the advantage of hiring somebody who does workers' comp for a workers' comp injury, hiring somebody who does Social Security for a Social Security injury, and further on down the road, because you know how to use the system, you know how to take care of the client to the best of your ability, and that's ultimately what you hope you've done by choosing an attorney is you've got the person who's going to best represent you, who's going to take the time to listen, is going to work hard, and evidently, according to what that gentleman shared with us, that's absolutely what you did. So congratulations in that case and so many others.
Yeah, thank you.
Yeah, absolutely, Jeff Roberts. I appreciate your time, guy. This is a difficult time for a lot of people with all these delays, and it stretches things out to resolutions, and it can be frustrating. But I think you've got a good way of addressing this with your clients, and hopefully they'll take some comfort in the fact that you're doing everything possible to wrap this up as quickly as possible, ultimately to their benefit. So,
yes,
my friend, thanks for your time, and we'll be back in about 2 weeks. Take care.
Thank you.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.